The defendant told me the judge would dismiss my testimony. I'm the judge hearing this case. I was in jeans and a worn sweater when Victor Kraus told me the judge would throw out anything I said in court. I'd stopped by my mother's apartment building on Maple Street to check on her after she'd called, saying the heat wasn't working again. Third time this month. It was February, and temperatures were in the 20s at night. She was 78 with arthritis and couldn't handle the cold. I'd been a judge for 12 years and had learned to compartmentalize my professional life from personal matters. But standing in that frigid hallway, listening to my mother's landlord dismiss her complaints, made my blood pressure spike in ways that courtroom testimony never did. Victor Kraus was the property manager for Riverside Towers, a rent-controlled building that housed mostly elderly residents on fixed incomes. He stood in the hallway with a clipboard, his expensive coat and polished shoes contrasting sharply with the peeling paint and water-stained ceiling tiles surrounding us. My mother had introduced me as her son Michael, and nothing more. Kraus barely glanced at me before turning back to her. "Mrs. Davison, I've explained this 3 times already. The heating system is old and we're working on repairs. These things take time. If you don't like the conditions, you're welcome to find somewhere else to live." His tone was dismissive, bordering on contempt. My mother clutched her cardigan tighter around her shoulders and I could see her hands shaking. Not just from cold, from fear. She'd lived here for 15 years since my father died. This was her home and her community. She couldn't just leave. I stepped forward and kept my voice level despite the anger building in my chest. The lease guarantees heat between October and April. It's a legal requirement. When exactly will the repairs be completed? Kraus looked at me properly for the first time, and something shifted in his expression. Calculation mixed with irritation. "Who are you exactly?" "Her son. The one who never visits." The accusation hit its mark because there was truth in it. I worked 60-hour weeks and visited maybe twice a month. Guilt was a weapon he wielded instinctively. "I'm asking about the repairs. When will the heat be restored?" Kraus smirked and tapped his clipboard against his leg. "I'll get to it when I get to it. Meanwhile, your mother can use a space heater if she's so cold. Though I notice she keeps her windows open half the time anyway, so maybe the problem isn't the heating system." That was a lie. My mother kept her windows closed and sealed with plastic in winter. I'd helped her do it in November. That's not true, and you know it. You're obligated by law to provide adequate heat. If you don't fix this within 48 hours, I'll be filing a complaint with the housing authority. Kraus's smirk widened into something uglier. "Go ahead. File whatever you want. I know people at housing authority. I know people everywhere. You think some bureaucrat is going to care about one old lady complaining? They'll send an inspector who will check a box and leave. Nothing will change." He leaned closer, and I could smell cigarette smoke on his breath. "But you know what will change. Her rent. When her lease comes up for renewal in May, I'll be increasing it. Market rates. She'll be paying double what she pays now." My mother made a small sound of distress behind me. I knew she couldn't afford double rent on her Social Security income. Kraus heard it too, and his smile showed he'd achieved exactly the reaction he wanted. "You seem like a smart guy. Lawyer, maybe? You understand how things work. Your mother has a sweet deal here, below market rent in a decent building. She wouldn't want to risk that over a few cold nights, would she?" The threat was clear. Complain and face retaliation through rent increases. It was illegal, but proving it would be difficult. His word against hers about the reasoning behind any rent increase. "This is tenant intimidation, and it's illegal. You can't retaliate against tenants for asserting their legal rights." Kraus actually laughed. "Prove it. Go ahead and try. You think you're the first person to threaten me with legal action? I deal with tenant complaints every day. I know every loophole and every delay tactic. By the time anything gets to court, if it ever does, it'll be your word against mine. And let me tell you something about judges in this county." He pointed his finger at me, and his voice dropped to something conspiratorial and smug. "They side with property owners, not with tenants. They understand that people like me provide housing and take financial risks. They don't want to discourage investment in this city, so even if you manage to get this in front of a judge, which you won't, he'll dismiss your testimony as biased family member testimony and side with the professional property manager who has documentation and proper procedures. That's how it works in the real world. You can play lawyer all you want, but at the end of the day, I win. I always win. I felt something cold settle in my stomach. Not fear, something else. The absolute certainty that this man had said these exact words before to other tenants, that this was his standard operating procedure. Intimidation, backed by cynical understanding of how the legal system could be manipulated. He'd studied the weaknesses and exploited them systematically. You seem very confident about how judges operate. My voice was flat, and Kraus must have heard something in it because he looked at me more carefully. I've been to housing court plenty of times. I know how these judges think. They're overworked and underpaid, and they don't want to deal with every tenant complaint that comes through. They want to move cases quickly. They want documentation and professionalism, and I provide both. Some nobody tenant complaining about cold nights. That gets dismissed in 5 minutes. I've seen it happen dozens of times. He straightened his coat and prepared to leave. So here's my advice. Tell your mother to buy a space heater and stop complaining. Be grateful she has a roof over her head at the rent she's paying. And don't threaten me with legal action because I will make her life very difficult. The heat will get fixed when I have time to fix it. End of discussion. He turned and walked toward the elevator, his expensive shoes clicking against the worn linoleum. I watched him go and didn't say anything. My mother touched my arm and I could feel her trembling. Michael, please don't make trouble. I can't afford to move. I can't afford higher rent. I'll be okay with a space heater until he fixes the heat. I drove home to my house in the suburbs thinking about Victor Kraus's face when he'd said judges would dismiss my testimony. His absolute confidence in his understanding of how the system worked. His certainty that he was untouchable. I'd been a judge for 12 years and had presided over hundreds of cases. I'd always tried to be fair and impartial, to follow the law regardless of my personal feelings. But I'd also seen exactly what Kraus described. Landlords with professional documentation and smooth attorneys facing off against unrepresented tenants who couldn't articulate their complaints properly. Cases dismissed for lack of evidence or procedural failures. The system wasn't designed to be unfair, but in practice, it often was. That night I filed a complaint with the housing authority under my mother's name, documented the lack of heat with temperature readings and photographs, contacted a tenants' rights organization, did everything a concerned citizen could do. But I knew from experience how slowly the bureaucracy moved, how many complaints got lost or ignored, how landlords like Kraus had learned to game every system. Monday morning, I was back in my chambers at the county courthouse reviewing case files for the week. I'd been assigned to housing court for this month as part of the rotating judicial assignments. It wasn't glamorous work, and most judges tried to avoid it. Housing cases were tedious and emotionally draining. Tenants facing eviction, landlords seeking unpaid rent, disputes over deposits and damages. Most cases were straightforward but depressing, people losing their homes over a few $100s. I reviewed the docket, and my attention stopped on one case scheduled for Friday morning. Riverside Properties LLC versus Tenants, Association of Riverside Towers. A class action lawsuit filed by tenants against the property management company over habitability issues. The property management company was represented by Alan Whitmore, a competent attorney I'd seen in my court before. The tenants were represented by legal aid. I read through the case file with growing interest. 32 tenants had joined the lawsuit alleging systematic neglect of building maintenance, broken elevators, pest infestations, plumbing issues, and inadequate heat. The building address was my mother's building. The property management company's representative listed on the filing was Victor Kraus. I sat back in my chair and felt my heart rate accelerate. This was problematic. I had direct personal knowledge of at least one of the issues being litigated. I'd witnessed Kraus's behavior toward tenants. I'd filed a complaint myself. Any reasonable person would say I should recuse myself from this case due to conflict of interest. The judicial code of conduct was clear. Judges must avoid even the appearance of impropriety. I should call the chief judge immediately and request reassignment. My hand reached for the phone and stopped. I thought about my mother shivering in her apartment, about Kraus's confident smirk when he'd said judges always sided with property owners, about the dozens of times he claimed he'd seen tenant complaints dismissed. If I recused myself, another judge would get the case. Maybe that judge would be fair. Maybe that judge would see through Kraus's documentation and professional presentation. Or maybe that judge would do exactly what Kraus predicted. Dismiss the case quickly to clear the docket. Side with the landlord who had lawyers and paperwork. The tenants would lose, and nothing would change. I spent the rest of Monday researching the boundaries of judicial recusal. The standards were more flexible than most people realized. A judge wasn't required to recuse simply because they had general knowledge of the parties or circumstances. The key question was whether a reasonable person would question the judge's impartiality. I could argue that my involvement was minimal. I'd filed one complaint as a family member of a tenant. I hadn't been a party to the lawsuit. I hadn't hired attorneys or taken formal legal action against Kraus or the property company. But I knew I was rationalizing. I knew the ethical path was to recuse. I also knew that if I did, these tenants would likely lose. Because Kraus was right about one thing. The system often did favor property owners, not because judges were corrupt, but because landlords could afford better representation and knew how to navigate procedures. I made no decision Monday. Tuesday, I was in criminal court handling arraignments and preliminary hearings. Wednesday, I had a settlement conference in a complex civil case that went until 8 p.m. Thursday, I finally called my mother. "How's the heat?" I asked without preamble. "Still not fixed. Mr. Kraus came by yesterday and said the part they needed was delayed. Maybe next week." Her voice was resigned. She'd given up expecting actual help. "Are you using a space heater?" "Yes. You were right to suggest it. Though my electric bill is going to be terrible next month." She paused. "Michael, I don't want you to worry about this. I know you have important work. I'll be fine." Important work. Like presiding over a case where I could actually help her and the other tenants. Or recusing myself because it was the ethical thing to do. Thursday night, I barely slept. Lay awake, weighing my options and their consequences. If I recused, the tenants would likely lose, and Kraus would continue his pattern of neglect and intimidation. If I stayed on the case and ruled against the property company, Kraus could appeal claiming bias. Could argue that my personal connection to one of the tenants invalidated the ruling. Could potentially get the entire judgment overturned. Either way, the tenants might lose. But at least if I stayed, they had a chance at a fair hearing. Friday morning, I arrived at the courthouse at 7 a.m., reviewed the Riverside Properties case file one more time. The tenant's complaint was detailed and well documented despite being filed by legal aid. They had photographs of broken elevators and pest infestations, affidavits from multiple tenants describing the same patterns of neglect, temperature readings showing apartments consistently below the legal minimum. The property company's response was smooth and professional. They acknowledged some maintenance issues, but characterized them as minor and temporary. Claimed they were addressing everything according to proper procedures, included documentation of work orders and contractor invoices, the kind of paper trail that looked impressive to judges who didn't look too closely. I put on my robe at 8:45 a.m. and walked to the courtroom. Housing court was held in the smallest courtroom in the building, dingy and outdated with fluorescent lighting that flickered. Most of the gallery was empty, except for about 20 elderly people sitting on the left side. The tenants. On the right side sat Alan Whitmore and two people I didn't recognize, probably company representatives. I took my seat at the bench and the bailiff called the court to order. "All rise. The Honorable Judge Michael Davison presiding. Court is now in session." I looked down at the parties and saw Alan Whitmore shuffle papers at his table. Next to him sat a woman in a business suit and Victor Kraus. Kraus was looking at his phone and barely glanced up when the bailiff spoke. He hadn't seen me yet, hadn't made the connection between the judge and the man he'd threatened in the apartment building hallway 6 days ago. "This is case number 2024 HC 1856. Riverside Properties LLC versus Tenants Association of Riverside Towers. Is plaintiff ready?" Alan Whitmore stood. "Ready, Your Honor." "Is defense ready?" The legal aid attorney stood. Young woman, probably fresh out of law school. "Ready, Your Honor." I looked directly at Victor Kraus. "Will the parties please introduce themselves for the record?" Alan started with the standard introduction. "Alan Whitmore, representing Riverside Properties LLC. With me today is Karen Yates, the property owner, and Victor Kraus, property manager." Kraus finally looked up from his phone as his name was called. His eyes swept up to the bench and stopped on my face. I watched the recognition hit him in stages. Confusion first, then realization, then something close to panic. His face went pale, and he grabbed Alan Whitmore's arm, leaning in to whisper urgently. I continued, as if I'd noticed nothing. And for the defense? The legal aid attorney introduced herself as Jennifer Cho and listed the 32 tenant plaintiffs by name. My mother's name was 14th on the list. Mr. Whitmore, I see you're moving to dismiss this complaint before we proceed to testimony. Would you like to present your argument? Alan stood again, but Krause was still whispering frantically in his ear. Alan looked annoyed and confused. He clearly had no idea what his client was trying to tell him. Your Honor, may I have a brief moment to consult with my client? You may. I watched Alan lean down and listen to whatever Krause was saying. His expression changed from annoyed to concerned to skeptical. They whispered back and forth for about 30 seconds. Then Alan straightened up, and his face was carefully neutral. Your Honor, my client has just informed me of a potential conflict of interest that requires the court's immediate attention. May we approach? You may. Both attorneys came to the bench. Krause stayed seated, but he was staring at me with an expression I couldn't quite read. Fear mixed with calculation. Alan spoke in a low voice. Your Honor, my client informs me that he had an encounter with you last week at the Riverside Towers property, that you were visiting a tenant who is one of the plaintiffs in this case, that you made threats about filing complaints and taking legal action. He believes this creates a conflict of interest that requires your recusal. Jennifer Cho looked startled. She clearly hadn't known about any of this. I nodded slowly. Mr. Whitmore is correct that I visited my mother, who is a resident of Riverside Towers, last week. She had complained about lack of heat in her apartment. During that visit, I did speak with Mr. Krause about the heating issue. I did indicate I would file a complaint with the housing authority if the issue wasn't resolved. I paused. I did file such a complaint under my mother's name. Alan looked uncomfortable. Then Your Honor must agree that this creates an appearance of impropriety. You have personal involvement in one of the core issues of this case. You've taken adverse action against my client. No reasonable person would believe you could be impartial. Mr. Whitmore, let me ask you a question. In your motion to dismiss, you argue that the tenant's complaints are exaggerated and don't rise to the level of habitability violations. You argue that the property management has been diligent in addressing maintenance issues. Are you aware that temperatures in multiple apartments have been recorded below 50 degrees for extended periods in violation of city housing code? Alan hesitated. The heating system is being repaired, Your Honor. Some delays are inevitable with older buildings. Are you aware that the elevator has been broken for 6 weeks, forcing elderly and disabled tenants to climb multiple flights of stairs? That's being addressed as well. Are you aware that Mr. Krause told me personally that judges in this county always side with property owners over tenants? That he was confident any tenant testimony would be dismissed as unreliable? Alan's face froze. He looked back at Krause, who had gone even paler. Your Honor, I wasn't aware of any such statements. I'm sure you weren't. Here's what I'm going to do. I'm going to make my conflict of interest a matter of record. Both parties now know that I have personal knowledge of some of the issues in this case. Both parties have the right to request my recusal. I looked at Jennifer Cho. Does the defense request that I recuse myself? Jennifer's eyes widened slightly. She understood what I was offering. A judge who had actually witnessed the defendant's behavior, who had personal knowledge that the landlord was lying about conditions. She spoke carefully. The defense has no objection to Your Honor presiding over this case. I turned to Alan. Does the plaintiff request my recusal? Alan looked trapped. If he said yes, he'd get a different judge. But he'd also be admitting on the record that his client was so worried about a fair hearing that he needed to disqualify a judge who had first-hand knowledge. That would look terrible. If he said no, he'd be stuck with me. He looked back at Krause, who was shaking his head frantically. Alan turned back to me. Your Honor, given the circumstances, I believe it would be appropriate for you to recuse yourself from this case to avoid any appearance of impropriety. Motion for recusal is noted. I'll need to consider it carefully and issue a ruling. In the meantime, we'll proceed with today's scheduled hearing. Return to your tables. They walked back, and I could see Alan having an intense whispered conversation with Krause. Karen Yates, the property owner, looked confused about what was happening. We'll now hear opening statements. Mr. Whitmore, you may proceed. Alan stood reluctantly. He was a professional and did his job competently. Argued that the property company had been reasonably diligent in maintaining the building, that some delays were inevitable, that tenants were exaggerating minor issues, that the lawsuit was frivolous and motivated by tenants who wanted to avoid rent payments. He spoke for 12 minutes and made his case well. Then Jennifer Cho stood for the tenants. She was nervous but prepared. Your Honor, this case is about a pattern of systematic neglect that puts elderly and vulnerable tenants at risk. It's about a property manager who has learned to exploit legal technicalities while ignoring basic human needs. We will present evidence that Riverside Properties has knowingly violated housing codes for months, that they've ignored repeated complaints, that they've retaliated against tenants who speak up, that Mr. Krause has specifically told tenants that legal complaints won't matter because the court system favors landlords. She glanced at me. We will prove that these tenants deserve better and that the law requires better. Call your first witness. Jennifer called an elderly man named Philip Sterling, who lived on the 4th floor. He testified about the broken elevator and how his wife with a walker couldn't leave the apartment for 3 weeks until the elevator was temporarily fixed. Alan cross-examined him about whether he'd documented his complaints properly, whether he'd paid rent on time. Philip got flustered and contradicted himself once. I could see this was what Krause had meant about unrepresented tenants not performing well in court. Next was a woman named Gladys Kimura, who described finding rats in her kitchen. She'd called the property manager 6 times before anyone came to put out traps. Alan asked her if she'd kept her apartment clean, and she got defensive. He implied the rats might be her fault. I interrupted. Mr. Whitmore, is there evidence that Ms. Kimura's housekeeping caused the rat infestation? Alan paused. No, Your Honor, but her apartment condition could be a contributing factor. Do you have evidence of that? Not at this time. Then let's focus on questions supported by evidence. The morning continued with testimony from 6 more tenants, each describing similar patterns. Broken things staying broken, complaints ignored, retaliation threats when anyone pushed back. Alan systematically tried to undermine their credibility, asked about late rent payments, about other tenant complaints, about whether they'd followed proper procedures for reporting issues. By noon, I'd heard enough to understand the pattern clearly. This wasn't about a few isolated maintenance issues. It was about systematic neglect, enabled by a property manager who understood that elderly tenants on fixed incomes had no leverage and nowhere else to go. We broke for lunch, and I returned to my chambers. Found a message that the chief judge wanted to see me. I walked to her office, and Judge Catherine Rivera looked up from her desk with a concerned expression. Michael, I heard about the motion for recusal in your housing case. Alan Whitmore called me during the break. He's concerned about the appearance of impropriety given your personal connection to one of the plaintiffs. I sat down. He's right that I have a connection. My mother lives in that building and is one of the tenants. I witnessed the property manager's behavior firsthand. Catherine frowned. Then you should have recused yourself immediately. Why didn't you? Because I don't think these tenants will get a fair hearing with another judge. Not because other judges are corrupt, but because this property manager has learned how to work the system. He has documentation and lawyers and knows all the right procedures. The tenants have a young legal aid attorney and their own testimony. I've seen a dozen cases exactly like this where the landlord wins on technicalities. Catherine was quiet for a moment. You know that's not a valid reason to refuse recusal. Your personal feelings about justice don't override the code of conduct. What if my personal knowledge makes me uniquely qualified to evaluate the evidence? I've seen how Krause operates. I know he's lying about addressing the maintenance issues. I know he intimidates tenants. Another judge would only see the paperwork and professional presentation. Catherine shook her head. You're rationalizing. If you stay on this case and rule against the property company, they will appeal. They'll argue bias. They might win. Then these tenants would have to go through the whole process again. Is that the outcome you want? I hadn't thought about that possibility clearly enough. An appeal based on judicial bias could indeed overturn any ruling I made. The tenants would be worse off than if I'd recused from the start. But if I recuse now, whoever gets the case might rule against the tenants anyway. At least with me, they have a chance. Michael, you're not thinking clearly about this. Your emotions are overriding your judgment. That's exactly why judges recuse themselves. You need to step back and let someone else handle it. She was right. I knew she was right. But I also knew what would likely happen if I did. What if I disclose everything and let both parties make informed decisions? I offered Whitmore the chance to request recusal, and he took it. If I grant the motion, I'm making the decision for them. If I deny it, both parties know the situation and can decide if they want to appeal later. Catherine considered this. That's ethically defensible, but risky. You'd be making yourself the issue in the case. I'm already the issue. Kraus made sure of that the moment he told me judges would dismiss tenant testimony. He thought he understood how the system worked. Maybe it's time to show him he was wrong. I returned to court at 1 p.m., and everyone was already seated. I noticed my mother sitting in the gallery now. She must have come during the lunch break. When she saw me on the bench, her face registered shock. She'd known I was a judge, but had never actually seen me in court before. I avoided looking directly at her. We'll continue with witness testimony. Ms. Cho, call your next witness. Jennifer stood. The tenants call Victor Kraus. That was a bold move, calling the opposing party as a hostile witness. Alan objected immediately. Your Honor, Mr. Kraus is not on the witness list. He's listed as a party representative. Ms. Cho has the right to call him. Objection overruled. Mr. Kraus, please take the stand. I watched Kraus walk to the witness stand. He was sworn in and sat down, his eyes never leaving my face. Jennifer started with basic questions. How long had he been property manager? What were his responsibilities? Kraus answered in short, careful sentences. He'd been property manager for 8 years. He oversaw maintenance, rent collection, and tenant relations. Then, Jennifer shifted. Mr. Kraus, how many complaints have you received about the heating system this winter? Kraus paused. I'd have to check my records. You don't remember generally? We receive many complaints. I can't remember specific numbers. More than 10? Possibly. More than 20? I'd need to check my records. Jennifer pulled out a document. I have here a log of complaint calls to your office obtained through discovery. It shows 43 separate calls about heating issues between December and February. Does that refresh your memory? Kraus's jaw tightened. If that's what the log shows. Were all those complaints addressed promptly? We addressed them as quickly as possible given the age of the building and availability of parts. The heating system hasn't been fully functional for 3 months. Is that correct? We've been working on repairs. Yes or no, Mr. Kraus? Has the heating system been fully functional at any point in the past 3 months? No. Are you aware that City Housing Code requires landlords to maintain indoor temperatures of at least 68 degrees? Yes. Are you aware that temperature readings taken in multiple apartments show temperatures below 50 degrees? I haven't personally verified those readings. Jennifer was doing well. She was methodically establishing that Kraus knew about the problems and hadn't fixed them. Then she moved to something more dangerous. Mr. Kraus, did you have a conversation with a family member of one of the tenants on February 10th? Kraus glanced at me, then at Alan. I speak with many people. Specifically, did you speak with the son of tenant Helen Davison on February 10th? Another glance at me. Kraus knew where this was going. I believe so. And during that conversation, did you tell him that judges in housing court always side with property owners? Alan stood immediately. Objection, Your Honor. This is irrelevant to the habitability issues. I looked at Alan. The question goes to Mr. Kraus's state of mind and understanding of his obligations. I'll allow it. Mr. Kraus, please answer the question. Kraus shifted in his seat. I may have made comments about how housing court generally works. Specifically, did you say that judges dismiss tenant testimony and side with property managers who have documentation? Silence. Kraus was trapped. If he said no, he was lying under oath. If he said yes, he was admitting he'd been confident enough in the court system's bias that he could ignore complaints. I may have said something to that effect. And did you say this because you've been to housing court many times before? Yes. How many times? I don't know exactly. Dozens. And in those dozens of cases, how many times have you lost? Kraus's face hardened. That's not relevant. Jennifer pressed. Please answer the question. How many times have you lost a housing court case? Not often. How many times? Maybe twice. Twice in dozens of cases. And based on that track record, you felt confident telling someone that you didn't need to address complaints because judges would side with you. Is that accurate? Krause didn't answer. Jennifer let the silence sit. Then she asked one more question. Mr. Krause, did you know that the person you made those statements to was Judge Michael Davison? Krause's eyes flicked to me. No. I didn't know. If you had known, would you have made different statements? I would have been more careful with my words. But not with your actions. Not with actually fixing the heat or the elevator or the rat problem. Just with your words. Alan objected again, but I overruled him. Krause was dismissed and walked back to his table looking shaken. The afternoon continued with more testimony. A building inspector who'd done a walkthrough testified about multiple code violations. A heating contractor testified that the furnace repairs could have been completed in days, not months, if the property company had prioritized them. By 4 p.m., Jennifer rested the defense case. Alan then presented his side, called Karen Yates, who testified that she'd relied on Krause's advice about building maintenance. That she wasn't aware of the extent of the problems. That she'd authorized funds for repairs as soon as she learned the full situation. She came across as genuinely concerned but detached from day-to-day operations. Alan called a different contractor who testified that furnace repairs in old buildings were complex and time-consuming. Called an accountant who showed that the property was barely profitable and major repairs were difficult to afford. His case wasn't weak, it just didn't address the fundamental issue. Whether intentionally or through negligence, the property company had failed to provide habitable conditions. We finished testimony at 5:30 p.m. I announced I would issue a ruling on Monday morning, and court was adjourned. After everyone left, I sat in my chambers reviewing my notes. Catherine was right that this was ethically complicated, but Krause had made one critical mistake. He'd said his contemptuous words to a judge. That gave me personal knowledge that his pattern of neglect wasn't just incompetence, it was calculation based on cynical understanding of system weaknesses. Monday morning, I issued my ruling. First, I denied the motion for recusal. I wrote a detailed opinion explaining that while I had personal knowledge of some issues, that knowledge made me more qualified, not less qualified, to evaluate the evidence. I noted that both parties had been fully informed of my connection and had the opportunity to request a change of venue or appeal. I acknowledged the risk of an appeal based on bias and explained why I believed the facts supported my decision regardless. Then I ruled on the merits. Found in favor of the tenants on every material claim. Ordered Riverside Properties to complete all repairs within 30 days. Ordered them to provide rent abatements to tenants for the months they'd lived without adequate heat. Ordered them to pay the tenants' legal fees. And I did something unusual. I issued specific findings about Victor Krause's conduct. I wrote that Krause had demonstrated systematic disregard for tenant welfare and housing code compliance. That his statements to me revealed a pattern of relying on system inefficiencies rather than meeting his legal obligations. That his confidence in avoiding consequences had enabled years of neglect. I referred my findings to the City Housing Authority and recommended they investigate whether Krause should maintain his property manager license. I sent copies to the State Attorney General's office for review. Alan Whitmore filed an appeal the next day, as I'd expected. The appeal argued judicial bias and improper consideration of evidence not formally introduced. It took 8 months for the appellate court to rule. During that time, the property company was required to make the repairs under bond. The heat was fixed within 2 weeks, the elevator within a month. They brought in exterminators and replaced plumbing. My mother called me after the heat was restored. "Michael, I didn't know you were the judge." Mr. Krause looked terrified when he realized. "Everyone in the building is talking about it." I asked if she was okay with what I'd done, if she felt I'd overstepped. "You helped us," she said simply. For the first time, someone in authority actually helped us. The appellate court decision came down on a Thursday. They affirmed my ruling in full. The opinion acknowledged the unusual circumstances, but found that my disclosure had been sufficient and that the facts supported my findings regardless of any personal knowledge. They noted that Krause's own testimony had established the pattern of neglect. They specifically cited his admission that he'd been confident judges would side with him. The appellate judges wrote that such confidence in system bias was precisely the attitude that required judicial correction. Victor Krause lost his property manager license 3 months later after the Housing Authority investigation found multiple violations across several properties. He'd been running the same playbook at 6 different buildings. Elderly tenants, neglected maintenance, intimidation tactics. The patterns were identical. Criminal charges weren't filed, but his career in property management was over. The buildings were sold to a new owner who brought in professional management. Alan Whitmore never spoke to me again outside of professional necessity. I understood. I'd put him in an impossible position with a client who'd created his own disaster. 5 years later, I'm still a judge, and I still get letters occasionally from former Riverside Towers tenants. They thank me for seeing them as people rather than case numbers, for understanding that justice sometimes requires judges to make difficult choices about their role in the system. I never regretted staying on that case, though I'm not certain I'd make the same choice again in different circumstances. What I learned was that Victor Krause had been half right. The system often did favor landlords over tenants, not because of corruption, but because of structural advantages in resources and legal representation. But he was wrong about one critical thing. Judges, when presented with clear evidence of systematic abuse, would act. We just needed to see beyond the professional presentations and documentation to the reality underneath. And sometimes that required personal knowledge most judges didn't have. Thanks for watching till the end. Make sure to subscribe and like to not miss the next story.